Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I think it's about time we talk about the NFA again. That's right, the National Firearms Act. I mean, is there really any historical analog going all the way back to the time of our founding that would justify a piece of legislation that was enacted into law in 1934? Maybe it's time for us, rather than having a discussion about the NFA, that we just start dismantling it. Now, I've always said that if we're going to do this, it's going to be done piece by piece, and I have oftentimes stated that suppressors would be the easiest item, or at least the place where we could start kind of shoving a wedge into this issue. Well, I've had an opportunity to read another brief here, and I got to tell you that the defendants here have done a really, really good job, and candidly, the Department of Justice and the federal government has really painted themselves into a corner. And this brief has so much promise that I'm beginning to think that maybe short barrel rifles, that's right, SBRs, might be low-hanging fruit as well. I'll show you what's going on in this brief so that you can understand. So today, let's spend a few minutes and let's talk about the trap that could unravel the entire NFA. Okay, America, this is the case we're talking about. We're talking about the United States of America versus David Robinson Jr., a case that is currently in the 11th Circuit Court of Appeals. It is a case in which the defendant, Mr. Robinson Jr., was found to be in unlawful possession of a short barrel rifle. What made it unlawful? The fact that it was not a registered NFA item and he had not paid his tax. Now, he has challenged the constitutionality of the statute. His initial challenge was unsuccessful, with the lower court finding that this was a nuanced approach that was necessary due to some more recent societal concerns. The case now ends up before the 11th Circuit, but I got to tell you, his federal public defenders here have done a really, really good job. Let me explain what I'm talking about here. Whenever we're going to talk about does the text of the Second Amendment actually protect the conduct, we're always going to go back to cases like Heller. And if you really want to start geeking out, Heller is going to recite to a case called Miller. Now, Miller is a very old case that actually dealt with the constitutionality of the NFA as it related to the possession of a short barrel shotgun. And there the court clearly said that the NFA was constitutional because the Second Amendment only protected certain types of firearms, and that really is the genesis of the common use test. So now the Department of Justice really has two options when it comes to Miller. You could reject it, but why would you do that? Because it seems to be the easiest argument. Or you could embrace it, which is exactly what the Department of Justice did. The problem is by embracing the holdings of Miller, they arguably have completely undermined their argument. Let me show you how. As the Supreme Court explained in District of Columbia v. Heller, the only remaining holding from Miller is that the Second Amendment's protection extend only to certain types of weapons. So what are those weapons? In Miller, the court held it could not consider short barrel shotguns to be protected arms without evidence tending to show that possession or use of short barrel shotguns at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia. And then, in relying on another case out of Tennessee, the court stated that the only types of weapons which would typically be protected were those that are usually employed in civilized warfare and that constitute ordinary military equipment. Okay, so what the United States Department of Justice has said is, listen, if these arms really constitute something that would be issued as ordinary military equipment, then the Second Amendment covers them. Well, why is that important? Well, as the defendants point out here, that holding puts the government in a bind. If the government disclaimed Miller, then the government would have to forego its argument that this court is bound to affirm based on Miller's conclusions about short barrel shotguns. But in embracing Miller, the government runs headlong into the fact that under Miller, the Second Amendment protects arms that are part of the ordinary military equipment. And the government did not dispute Mr. Robinson's assertion in his initial brief that the standard issue rifle for the United States Army and Marines is an M4 carbine with a 14.5-inch barrel, a short barrel rifle. How a short barrel rifle can be the standard issue rifle for our nation's military, yet not be part of the ordinary military equipment, is left to the reader's imagination. A really, really fascinating and very intelligent argument. And they also point out, and Miller turned on the feature of short-barrel shotguns and the lack of any evidence tending to show that they were part of the ordinary military equipment or could contribute to the common defense. Whatever the merits of that conclusion about short-barrel shotguns, it does not apply to short-barrel rifles, the main weapon of choice for our nation's infantry. So true, so true. Now, of course, then the argument is the obvious. Short barrel rifles are in common use. And yes, that is exactly what Robinson's attorneys argue. The government suggests that over 500,000 short barrel rifles is not enough to show that they are in common use. That's right, the government is claiming that there's only about 500,000 short barrel rifles. Robinson's attorneys continue to state that argument is undercut by the Supreme Court precedent. In Catano v. Massachusetts, the court considered the constitutionality of a state law prohibiting the possession of stun guns. And as we know, a mere 200,000 stun guns was enough for the court to believe that they were in common use. Now, the United States government is claiming there's only 500,000 SBRs. We all roll our eyes. There's probably at least one state in the nation that has at least 500,000 SBRs. But as defense counsel points out here, also the 500,000 number drastically understates the number of short barrel rifles in circulation, at least according to the government. That is because the government's official position is that almost all braced pistols are properly classified as short barrel rifles. Oh, don't you hate when they use your own rule against you? So the actual number of short barrel rifles is around 532,000 plus 3 to 7 million. Now, of course, the reason we need to ban SBRs is because they are so inherently dangerous. We've heard all the arguments. Easy to conceal, very, very deadly. And of course, that's exactly what the Department of Justice argues here. Instead of underburdened by evidentiary support, the government argues that short barrel rifles are inherently dangerous because of their concealability and heightened capability to cause damage, no matter how many people are murdered with them. There are a few problems with that. And there are a few problems with that. You guys already have your ideas spinning in your head. But as defense counsel points out here, first, the government overstates the concealability of short barrel rifles. Short barrel rifles are still large weapons that cannot be concealed under anything short of a trench coat. One need purely pursue the dozens of readily available off-the-shelf short barrel rifles to confirm the obvious fact. For concealability, short barrel rifles are a poor substitute for handguns. Now, as we know, one of the initial inquiries is, anytime we're trying to analyze the constitutionality of gun control legislation, is does the plain text of the Second Amendment cover the conduct that's in question here? And the government is always looking for an escape hatch, and the way they're looking for an escape hatch is by reframing the issue in kind of an absurd way. Let me give you an example of exactly what DOJ did here and how defense counsel called them out on it. Under the government's reading, his course of conduct is not merely possessing a short barrel rifle, but is instead possessing an unregistered short barrel rifle. This conduct, the government argues, is not protected by the Second Amendment. That is wrong. In Bruin, the court considered whether carrying a handgun publicly for self-defense was protected by the Second Amendment, not whether unlicensed carry was protected. And they will do that over and over and over. They will add these extra conditions to make the inquiry a complete impossibility. And of course, what the government is doing, and we saw that this was going to happen, especially with the Rahimi case, we're beginning to see it with the Cargill case, is that there's a lot of sloppy language in there. There's a lot of little legal hooks that they can hang their hats on, like relevantly similar, a more nuanced approach. And this is, of course, the approach that DOJ is taking here. Defense counsel calls them out on it this way. The government acknowledges that the NFA is not identical to those historical regulations. That is quite an understatement. Not only are those historical regulations not identical to the NFA's regulations, the how and why those regulations burden the Second Amendment are so dissimilar as to be contradictory. And of course, if that is the case, that brings us to the $64,000 question, doesn't it? Or in this case, really just the $200 question, which is if the NFA is unconstitutional in its inception, then the government is taxing gun owners based on an unconstitutional statute. As defense counsel points out, because Mr. Robinson's conduct of possessing a short barrel rifle is protected by the Second Amendment, the central question here is whether there is a historical tradition of requiring people to register and pay taxes on certain firearms before possessing them. which of course there is not. Now, once again, the Department of Justice has painted themselves in a brutal corner as it relates to the taxation issue as well, because they had two cases that they probably could have tried to hang their hat on. But for whatever reason, they tried to say, no, those cases don't really apply, and they have now left themselves completely exposed on the taxation issue as well. As defense counsel points out, the government argues that the fee jurisprudence doctrine from Cox v. New Hampshire and Murdoch v. Pennsylvania does not apply here because that doctrine uses means-end scrutiny, and Bruen rejected the use of means-end scrutiny in the Second Amendment context. So according to the government, only the Bruen test needs to be satisfied. If the government is correct, so much the better for Mr. Robinson. Considering the NFA's $200 tax under the Bruen framework means that the government must show a distinctly similar historical regulation imposing a similar prepossession tax, the government did not and cannot do so. Fascinating case. Defense counsel has really set up the issues here. The Department of Justice is going to have to wiggle in a lot of different directions to get out from under this trap that has been set. The case, once again, is United States of America versus David Robinson Jr., filed in the 11th Circuit. We're going to link up the memorandum that we relied on in making this video so that you can geek out on it for yourself. You might have questions about this or anything else related to what's left of our Second Amendment rights. If you do, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video. If you do, click on that link right there. And if you want to be part of Washington gun law's new newsletter, click on the link down below in the description box and get signed up today. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.